This podcast is a product of the Florida Academy of Collaborative Professionals. Nothing in this podcast should be considered legal advice. To find a collaborative professional near you, visit www.collaborativepracticeflorida.com. I'm Cash Eaton, an accredited collaborative family law attorney and a member of the Florida Academy of Collaborative Professionals, also known as the FACP. Today's guest is Cash Eaton, and we have the same last name because he's my son. So Cash is a board-certified marital and family law attorney with Sasser, Sestero, and Roy in West Palm Beach. He dedicates his practice exclusively to marital and family law. He represents clients in dissolution of marriage, paternity, modifications, enforcements, complex children's issues, alimony, child support, on the trial and appellate court levels. He's an active member in the family law section of the Florida Bar, and he currently serves on the section's executive council and legislation committee. And he was trained in the collaborative process in 2013. I looked it up this morning. That's 10 plus years ago.
That's true. That's kind of scary now that you see that.
So the reason I wanted to have you as a guest on the podcast today is I wanted to talk to you about the difference between the collaborative process and what people say the cooperative process is, and to understand your perspective of why more firms, law firms, family law firms, haven't embraced collaborative. Instead, they're saying, oh, we do cooperative. So what's the difference, and why do you think it's not being as embraced as I would like it to be?
Well, first, thank you for having me. I'm very proud to be here on the podcast and talking with you today and talking to all the viewers about family law and the collaborative process or the cooperative process. And keep in mind, that's just a phrase that we've come up with because, as you kind of were alluding to, my firm, we don't take a ton of collaborative cases. Our firm does have lawyers who are collaboratively trained, and we do some collaborative cases, but no, it is not a bulk of our practice. It hasn't been not accepted, but utilized as frequently in a lot of the cases that we handle and stuff like that. So the thought process behind it of what it means when we use the term a cooperative process is that we try and work with whoever is on the other side, whatever opposing counsel that might be, whatever opposing party, if they're unrepresented, we try our best to work with them to come up with creative solutions to settle cases instead of trying to push people towards trial or towards very strenuous litigation. But sometimes it's unavoidable from our perspective. And so we try our best to work cooperatively with the other side. We act as ethically as we can. We try and be solution oriented, but we're not prescribing to the rules, the procedures, the entire system, so to speak, of collaborative law. And there's a couple different reasons for that. One, I feel like that a lot of the clients that our firm handles or that come in for initial consults, they are extremely high conflict. Our firm has a fairly high profile. We handle some pretty high profile cases. And when people are coming to us, a lot of times it's because they are in a really high conflict situation with the other party. And so you're taking it, and whether it's you're the client's the high conflict client, The other side is a high conflict client or a high conflict party, or both of them are, you've got a high conflict situation. And because of that, it's very difficult to get someone to prescribe to a process where you're going to pick neutral experts, a neutral financial person. Meet regularly can also be a big problem from our perspective with very high conflict clients. Choosing mental health experts, it can be very difficult to get people to buy into that. And because it's very difficult to get people to buy into that, well, frankly, they don't. And if they don't, then I don't feel like the collaborative process really is an effective process for handling people like that, because you've got to get both sides to really buy in. And it's one of those things, like most things, where the more you put into it, the more you get out of it. And so that's a little bit of why our firm doesn't seem to have or take or have clients who are asking about the collaborative process.
So you're board certified, and in becoming board certified, you have to take a test, right?
Correct. Yeah.
And so I heard, and so that collaborative is now, or was recently, on the test. That's one of the subjects that you have to be prepared for, right?
Right.
So do you think that more family law attorneys will be getting trained in collaborative and embracing it, since it is part of the statute and it's on the board cert exam? Is that going to help spread the word?
I think it'll definitely help spread the word. I think it's an increase in awareness, in knowledge, in even just with legal consumers, that they're starting to learn more about what that process is, and that it exists, and that there are pros and cons to it, and because of that, I really think that there will be an increase in the collaborative process. And I think that's especially true because the court system is very overburdened for a lot of depending on where you are, of course, in Florida, and everywhere in Florida, it's a bit different. But where I am in Palm Beach County, it's a high population county. There are a lot of family law cases that get filed every year, and you only have 9 judges who are handling the entire load of thousands of active cases. With a court system that is that overworked and has that many cases to deal with, you're going to find people who want to utilize a process that, or at least I think that they'll want to use the process that gets them results a bit quicker, or at least gets them to start dealing with substantive issues in their family law case quicker, and with professionals, and making sure that they're being heard and addressing financial issues. Because honestly, in a traditional litigation style case, that can be extremely difficult just to get into court to get a temporary relief hearing. And in Palm Beach County, we're limited in our temporary relief hearings to 30 minutes. So it's even difficult just to get a 30-minute hearing. And a lot of times you have clients who need temporary relief or to address temporary children's issues, temporary financial issues right now. They might have just separated and left the house. One party might have just separated and left the house. Bills might not be getting paid, and there needs to be a prioritizing of what is going to get paid and when it's going to get paid and how. And a lot of times the court system just does not have the time to address those issues on an expedited basis. They only, they have the time, they have a limited amount of time. The judges have their schedules, and they have thousands of cases. A collaborative process allows for the addressing of immediate issues rather quickly, especially if both parties are buying in to that process. So I think people are going to want and like that more if, you know, you have a system that you can put in place that allows for the addressing of issues rather quickly, then um, then that's why I think that collaborative will grow in popularity, especially over time.
That's a really good point. I never thought about that. Next time somebody asks me, I'm going to say, well, you know what? If you want to get this done, I know a way.
Right.
Talk to me about professional meetings, because in collaborative, the professional team meets like 30 minutes before the full team meets for 2 hours,
Mhm.
and they discuss, what's going to take place and how to help the clients. That's part of the collaborative process. But I know that you use professional meetings in your practice, whether or not you're doing collaborative or cooperative or whatever. Will you talk to me about the value of the professionals meeting, even if
Right.
via Zoom, via phone, and what's the value in that, so people can understand why they're paying for, the lawyers and the financials to all be talking when they're not present?
So one of the things with the collaborative process is that is basically required. Like that when you're walking into a collaborative case, you know that that is part of that process, that you're going to be doing these professional meetings. That's how you get things done, because you're not going uh, to court or going through the court system in order to, you know, have motions heard or to, get things done, so to speak. You're meeting regularly. With when you're not in a collaborative process and you're going down a more traditional litigation road, so to speak, in your case, one of the first things that we talk about in our in our client consults, especially when we're asked how long is this going to take or how much is this going to cost, is we as the lawyers always ask, well, who's on the other side? And the reason why is because not every attorney has a ton of family law experience. Some people come in and they primarily do criminal law, or they primarily do immigration, and they only take family law cases occasionally. Well, basically whenever they come in the door randomly. And in cases like that, the other attorney might not have a lot of experience with family law. They might not even know what a professionals meeting is, or they might not truly know the ins and outs, the details of our law and family law and case law and all those types of things. And when you've got situations like that, it's very hard to have professionals meetings with them because they don't really want to work with you. They either want to go straight, they want to go to court, they just want to argue all the time. They want a judge to make all the decisions for them. And so when you have a situation like that, it's going to be very hard to have professionals meetings. So you're kind of, in answering your question, I'm kind of excluding those situations from that process, because really we have a lot of cases we've done, we have a lot of very experienced attorneys. We know a lot of the attorneys in the area because we only handle family law cases. And so we generally work well with a lot of different family law attorneys. And with those attorneys that we work well with, who are also attorneys that want to try and resolve cases for their clients, that want to try and reach settlement, that want to try and solve issues or be solution oriented. When we work with those attorneys, we like to set professional meetings and like to do it routinely, because there's a lot of different things to be checking in on. How are the parties doing? What are the living arrangements like? How are the children doing? What issues do we need to address from a time sharing schedule? Holidays are coming up. How is that going to be handled? How are exchanges going to be handled if someone's got unexpected travel plans, business plans, whatever it might be? And that's just the children's issues. If you've got two lawyers who are working cooperatively with each other, it can be very beneficial because it helps to get ahead of issues, because you do have a court system where it's very hard to get hearing time. And you don't want your clients to be waiting around 3, 6, 9 months for a hearing in order to get a ruling on what these parties are going to do. You want to try and address these issues quickly. The same thing goes with financials issues. So at a professionals meeting, and the reason why we use them is that if both sides are trying to reach solutions for their clients, you don't want to have fights about whether or not everyone has all the discovery they need in order to make decisions. You don't want fights about, well, the kids say this about dad, oh, the kids say this about mom. It's about trying to get a baseline as to what facts and circumstances exist in this case, in this party's circumstances, in hopes of trying to come up with creative solutions to resolve client issues. I mean, that's really the benefit of professionals meetings, because you don't want those issues like discovery or documents missing or temporary relief issues to really be addressed in motions and only be addressed by hearings, or you're going to have a divorce that lasts 2, 3. I mean, we have a case right now in the firm that's been going on since 2019. I mean, who wants to be getting divorced for 5 years? That's a very long time. So that's what the professionals meetings are for. And that's why it makes sense and to do it in collaborative too. And it's something, that's been going on for a while, good lawyers meeting in order to try and resolve cases. It's just that the collaborative process really adopts that as a way and the mechanism to get things done.
So when somebody is getting a divorce and they start lawyer shopping,
Mhm.
I mean, many people, a lot of family law attorneys, as I do, because this is who we work with. Give some advice to somebody who is going to start lawyer shopping. How do they find somebody? Or if they find someone, this is who my neighbor used. What are some of the questions you think they should ask, of the attorney? Or what did some people ask you and you think, oh my gosh, that's a good question.
I think that some of the questions that need to be asked by a potential client to their attorney is, one, I do think it's important to know what type of trial experience they have. It's easier for me to explain to people the type of trial experience I have because I'm board certified. So you have to have a certain level of trials. And it's not that you want to know what your attorney's trial experience is because you're trying to gear yourself up to go to court. It's more like, I just want to make sure that if this process of trying to work out these solutions does end, then I want to know that they have some experience and that they're going to be okay in that kind of, because I really do see trial as a bit of the nuclear option. You do not want to go to trial. Most cases don't go to trial, but you want to make sure that that's at least in your attorney's back pocket, that they have some experience and that they can handle themselves and take it all the way to the end. That's one thing. But also, I think that sometimes potential clients really want to spit out all of their information, which is understandable. You want your attorney to be knowledgeable about your facts and circumstances. But I also think that there should be a fair bit of listening that's going on when you're the client, because you should hear about how, or take stock of how that attorney is speaking about other attorneys. Because if they are high conflict with other attorneys, or, oh, they're rotten, oh, they're terrible, oh, we don't get along, and all that kinds of stuff, you're going to probably have an attorney. If you hire that attorney, you're probably going to have an attorney that is going to be fighting on a lot of things that maybe they don't need to be fighting on, like discovery, which can get very expensive to find every single statement and every single document and not use logic and reasoning in order to come up with conclusions about financial circumstances, or who are going to, just yes you to death on all these parenting issues because that attorney wants to fight the other attorney or fight all the attorneys and take everything to court. Those are those are real red flags, I would think, as a client in meeting with a potential new attorney. Also, I would try and, as the client, take trial out of the equation. Say, I really don't want to go to trial. What are you going to do, Mr. or Mrs. Attorney, to help me resolve my case without going to trial? What are some, and then that's when we have discussions about things like, well, I think we should have professionals meetings. I think that and we have them regularly and routinely. I think we need to start going or really start gearing up to go to mediation quickly, and maybe not on a global basis because we don't have all the information, but certainly on a temporary basis so that we can try and um, get some resolution to parenting plans, pickups, drop-offs, all the granular details in a family. You want an attorney who is really trying to push for those types of alternative dispute resolution mechanisms, because that should be telling you that that person is not just in there for their own personal glory of going to court and winning trials and being, TV's trial lawyer of the year or whatever, because that's someone who's not trying to get those types of accolades. They're working for you, and they know that, and they respect that, and they're looking out for your best interests.
And then will you just speak before we wrap this up about how expensive it is to litigate? I mean, that is the traditional that we've all seen in movies and TV and most people know about,
Sure.
but they don't, in the end, when the judge rules, you don't necessarily get the results you get. But why is it so expensive?
So there's a bunch of different factors and variables that I would say that leads to a case becoming very expensive, or having a litigated case becoming very expensive. And some of those things are on the individual client, either your own client or the other party. And then there's sometimes it has to do with the lawyers. But one of the things that makes litigation very expensive is the discovery process. And there's a reason for that. A lot of people are not exactly very organized in their personal finances. And if they're not organized in their personal finances, they don't want to go and start pulling statements and pulling financial data and pulling financial information, because it takes a lot of time and it takes a lot of attention to detail, and it takes a good deal of commitment when you've got a million other things going on in your personal life and you're in the process of getting divorced, and every time you're looking at statements, it's just making you cry for obvious reasons, or making you angry, or making you all sorts of things. It can be a very long and tedious process. I understand that. I think every lawyer pretty much understands that. But understand, if my staff members have to go and hound for documents from that person so that they can be compliant with their discovery obligations, that takes a lot of time. And lawyers and their staff, they charge for time. That can get very expensive. If you're looking at it on a more macro level, discovery can be very expensive because some attorneys, they really like to make money that way, in the sense of that they want to fight about discovery and fighting to make sure that they get every single statement and every single document. Well, what's the real return on the time that is being invested in order to make sure that every single statement is received? And what is the point of, statements 5 years back? In some cases, it is relevant, but not in every case, because a lot of the decisions that a judge has to make in a family law case are present day determinations. What is someone's income now? What are someone's assets valued at today? Or, when this case first got started, first initiated. Judges don't generally look at what are the values of assets 5-10 years ago. In some cases, yes, but not in every case. And so that process and the investigating of that obviously can be very expensive. That is one thing about collaborative law that I think is very beneficial, is that it does seem to be a more future or present day and future focused process, of how are we going to resolve these issues today. Sometimes I think that in the litigation process, we get a little bogged down in the weeds of how have things been over the past 5 years or 10 years in long-term marriage cases and things like that. And it's because we want to look at what someone's income has been averaging over the past years or what the business has been bringing in over the past years. Sometimes we get a little too past focused, and that's why I think it makes it very expensive, because it's a lot of time to analyze that amount of data. And whenever you've got something that takes a lot of time, there's a lot of charges that are generally, or fees that are associated with that. So I think that's a big reason why. But another big reason why is because hearing prep is very expensive. There are a lot of clients who want a litigation process because they are ready to stick it to the other side in a lot of ways. And when you've got situations like that where you're constantly going to court, I mean, you have to prepare for those hearings. You have to get all of the evidence as a lawyer. You have to get all the evidence collected. You have to get all of your arguments collected, all the case law, memorandums of law, responses to motions. Sometimes in order to let the judge know what your position is, you have to do witness prep. You have to do deposition transcript review and highlighting and digest in order to, if you're going to use previous testimony. That takes a lot of time to prepare for, especially if it's an all-day hearing or a multi-day hearing, and that cost gets very exorbitant. It does, because of the amount of time that it takes in order to prepare for it. And that's where I always am warning clients and people that I just talk casually about family law with, is that what is the return on that investment? Because you might not get the ruling that you want from the judge, and you've spent a lot of money in order to get there. That's why I generally also don't like temporary relief hearings. If I can resolve temporary issues without going to court, that's always, especially the temporary ones, if that's always better, because then if I'm not doing that, then my client is paying for me to basically have a mini trial and then prepare to get ready for a final trial. I mean, 2 trials will always be more expensive than 1 trial. So those are some of the factors that really play into the cost associated with a litigated case in a litigated format.
Well, thank you for explaining that. And thank you for being our guest today. And I hope you and your firm do more collaborative cases.
It's something to always consider. And thank you very much for having me. I love talking about both processes, all the processes, because getting solutions for Florida's families is the reason why we do this, because it's a very difficult time that people are going through, and you want to be there for them to give them the best base possible in order to start their new unmarried lives. So
You're right.
thank you so much.